everyone, this is Urvashi Chauhan and you are watching Courts Today by Livelaw. We bring to you the latest and in-depth legal coverage. Here is a brief of what all happened in the Indian courts today. Starting with the much-awaited judgment on the dispute between the Delhi government and the centre over the control of administrative services. The Constitution Bench of the Supreme Court today held that the Delhi government has legislative and executive power over administrative services in the national capital, excluding matters relating to public order, police and land. The issue in the case was whether the government of NCT of Delhi had legislative and executive powers in relation to services under Schedule 7 List 2 and Entry 41, and whether the officers of the various services such as IAS, IPS, etc., who have been allocated to Delhi by Union of India come under the administrative control of the government of Delhi or not. The entire issue is with respect to Article 239AA, which declares the Union Territory of Delhi to be administered by an LG who works on aid and advice of the elected Legislative Assembly. This aid and advice clause relates only to matters under the state and concurrent lists on which the elected Assembly of the Delhi has powers. And this excludes the subjects of public order, police and land. Further, if the LG has any difference of opinion with the Council of Ministers, he can refer it to the President. This dual control between the LG and the elected government is what leads to a power tussle. The central government's stand has been that because Delhi is the national capital and the face of the country, it must have control over administrative services, which include appointments and transfers. However, the Delhi government argues that in the interest of federalism, the elected representatives must have power over transfers and postings. Today, the Supreme Court has clarified that the Lieutenant Governor shall be bound by the decision of Delhi government over services apart from public order, police and land. This judgment elaborates on the importance of federal structure of the country. The bench has observed that although Delhi government is not a full-fledged state, yet it is empowered to legislate under List 2 and 3. And therefore, it has to be ensured that governance of the state is not taken over by the union. To know more about the matter, you can click on the link given in the description box below. And now coming to another Supreme Court judgment which has been in headlines throughout the day. The rift within the Shiv-Sena party between Uddhav Thackeray and Eknath Shinde groups, which led to the change in the government in Maharashtra in July 2022. You already know that since June 2022, the Supreme Court has been hearing various petitions filed by leaders from the Thackeray and Shinde factions of the Shiv-Sena. In June 2022, a group of Shiv-Sena MLAs led by Eknath Shinde rebelled against Uddhav Thackeray. When it became evident that the rebel would call for a trust, the Shinde group received disqualification notices from the then Deputy Speaker. The faction moved the Supreme Court to consider whether the rebels should be disqualified or not. They also challenged the disqualification notices served on Shinde and 15 MLAs supporting him. The top court granted them extended time to file responses to the disqualification notices. It later gave the go-ahead to a floor test called by the governor. Because the then government did not have the requisite numbers, Uddhav Thackeray resigned as the chief minister. Subsequently, the Thackeray camp filed petitions before the Supreme Court challenging the summoning of assembly by the governor for a trust vote, the swearing in of Eknath Shinde as the chief minister with the backing of BJP, the election of new speaker, etc. In August last year, a 3-judge bench of the Supreme Court had referred the matter to a constitution bench. Today, the Supreme Court delivered its judgment and inter alia held the following. Firstly, the Supreme Court held that the Speaker's decision to appoint Mr. Govt, who was backed by Shinde Group as the whip of the Shiv-Sena party, was illegal. Secondly, the court held that the decision of the governor to call for a floor test on the rebellion of Eknath Shinde-led faction and to direct then Chief Minister Uddhav Thackeray to prove his majority was wrong. Thirdly, despite holding that the governor and the speaker erred, the court refused to restore the Uddhav Thackeray government as he had voluntarily resigned without facing a floor test. Lastly, the Supreme Court referred Nabam Rebia judgment to a larger bench, stating that the issue did not strictly arise in the present proceedings. To know in detail about the judgment, you can check our detailed coverage on this issue by clicking on the link given in the description box below. And now coming to the 10th day of Constitution Bench hearing on legality of same-sex marriage in India. Today, the parties on both sides concluded their arguments and the Supreme Court reserved its judgment on the case. The bench, comprising CJI D.Y. Chandrachud and Justices Sanjay Kishan Kaul, S. Ravinder Bhatt, Hima Kohli and P.S. Narasimha, started hearing the matter on April 18th. There are 20 petitions before the bench filed by various same-sex couples, transgender persons and LGBTQIA+ activists challenging the provisions of the Special Marriage Act, the Hindu Marriage Act and the Foreign Marriage Act to the extent these legislations do not recognize non-heterosexual marriages. As we kept you updated throughout, you already know that during the course of the hearings, the bench decided to confine the issue only to Special Marriage Act and to not touch the personal laws. Another significant development was the union government willing to consider if certain rights could be conferred upon same-sex couples without legal recognition of their marriage to ensure them access to welfare and social security measures. The National Commission for the Protection of Child Rights also intervened in the matter, expressing concerns about allowing the same-sex couples to adopt. On the other hand, the Delhi Commission for the Protection of Child Rights supported the petitions and backed the right of same-sex couples to adopt. The judgment has been reserved by the Supreme Court today. Stay tuned with livelaw to know the verdict in the case. In another update, the Bihar government today moved the Supreme Court with a special leave petition challenging the Patna High Court's order dated May 4th, which put an interim stay on the caste-based survey in the state. In its order, the High Court also stayed circulation of the information collected to political parties, calling it a matter concerning right to privacy. The state government in the SLP has stated that High Court granted a stay on the caste-based survey, which was on the verge of completion, and hence, at this stage, the stay is causing irreparable loss to the state. It has further been asserted that the collection of caste-based data is a constitutional mandate under Articles 15 and 16. The SLP has been moved 2 days after Patna High Court clarified that in its May 4th order, it has not set aside the entire caste-based survey. It has only stayed the further work of the survey and has also stayed dissemination of the information collected to the political parties. For further updates on the same, stay tuned. In another update, the Supreme Court today decided the preliminary objections on the maintainability of suit filed by State of Meghalaya challenging Section 5 of Lotteries Regulation Act in favor of the state. It held that the state of Meghalaya is entitled to take the matter forward on the merits. State of Meghalaya and State of Sikkim had approached the Supreme Court against the decision to ban their state lotteries in other states. The dispute emerges from the power given to the state government by the centre under Section 5 of the Act to prohibit the sale of tickets of a lottery organised, conducted or promoted by any other state. Today, the bench granted 4 weeks' time to the contesting defendants to file their response in relation to the interim relief. The Kerala High Court today observed that it was lack of protocols and systematic failure that led to the gruesome murder of a 23-year-old house surgeon who was stabbed multiple times by an injured man brought to the government hospital in a police jeep. Referring to the house surgeon, the court said, at 3 a.m. in the morning she was there to serve. She was serving the people. The system has failed her, her parents and us. The court directed the police department to put in place protocols for the manner in which persons in custody of the police are to be presented for medical checkups. The court said that the priority must be to protect the doctors, healthcare professionals, students, interns, house surgeons, and such others, or else the faith in the system will erode. Significantly, the medical community has gone on a strike in light of the incident. And now an important update from the Delhi High Court, which today constituted a committee to conduct surprise inspections in Tihar jail. Justice Pratibha M. Singh sought a report on the nature of food and the food items made available to the inmates at all times and hygiene level maintained in the sitting area and canteen. The court was hearing a plea moved by 2 inmates presently lodged in Tihar jail seeking direction to the superintendent of jail to ensure that proper food facilities are made available for all inmates. According to the petition, although there is a prescribed diet in the prison rules in terms of quantity and nourishment, the same is not being followed in Tihar jail, as a result of which the physical health of inmates is adversely affected. The matter will now be heard on July 20th. And lastly, coming to an update from the Delhi High Court, which today reserved order on the bail plea of Aam Aadmi Party leader and former Deputy Chief Minister Manish Sisodia in the CBI case alleging corruption in implementation of excise policy for 2021-22. Justice Dinesh Kumar Sharma also directed the concerned superintendent of jail to ensure video conference meetings between Sisodia and his wife between 3 to 4 p.m. every alternative day till disposal of the bail plea. The court will also decide Sisodia's plea seeking interim bail on the ground of illness of his wife. As you know, Sisodia is currently in judicial custody in the cases registered by the CBI and Enforcement Directorate. He was denied bail by the special judge in CBI case on March 31st. Thank you for watching. If you wish to know more details about the cases I mentioned here, you can check the links given in the description box below. Stay ahead with quick legal updates only on Live Law. Do not forget to like, share and subscribe and support us.